what's important for the court to know, Your Honor, is that Mr. Zach Sneesby, which is one of the witnesses that the defense fortuitously decided to withdraw, actually was interviewed the week before, the last week in May. And during his interview, he revealed that he was standing very close to Mr. Baldwin when he shot and killed Helena Hutchins. And Mr. Sneesby specifically said he saw Mr. Baldwin pull the trigger. And as you know, the defense position has always been that he didn't pull the trigger. Well, now there's an eyewitness who actually says he saw him pull the trigger. And he said this during his pretrial interview. The state conducted additional investigation and determined that it would then withdraw its objection or opposition to these witnesses. There was no bait and switch. There was no bad faith. And what's important, Your Honor, is that these were...
So bad faith might be if the state changed its position. What happened? Okay, sorry, folks, I got confused. I have too many tabs open. Bad faith might be where the state changed its position in the absence of any new information for strategic purposes or to ambush the defense or something along those lines. Here, the state's saying, yeah, we changed our position because we got new information. We learned from his interview that this witness is prepared to testify that he saw Alec Baldwin press the trigger when Baldwin discharged that bullet into Helena Hutchins. And the defense has been arguing throughout that the gun went off by itself. Alec Baldwin has said repeatedly he never touched the trigger. That's relevant to an issue in dispute in this case. So that's not bad faith. That's good faith.
Defense witnesses. It's not like these were state witnesses that were not made available for pretrial interviews. These were defense witnesses. Presumably, the defense had spoken to them, had investigated what they were going to say, and they disclosed them on their witness list. So for them to now argue prejudice is, I would respectfully submit, disingenuous, because they are seeking to exclude and claiming prejudice because they withdrew and didn't have time to set up pretrial interviews of their own witnesses. Well, if we're going to list witnesses on our witness list, we first interview them, find out what they have to say, and then we list them on our witness list if we believe their information or the evidence they're going to present is relevant. On May 6th of this year, the state filed its witness list. The 45th witness, as the court noted, is any witness disclosed by defense, called as a witness by the defense, or listed on the defense witness list. The fact that the state then listed the witnesses the defense sought to withdraw on its witness list does not result in a violation of the rule, because we did, as the court pointed out, the 45th witness was any witness listed or disclosed by the defense. Your Honor, with regard to the prejudice, because before the court can impose the severe sanction of exclusion, the court has to find that there is prejudice. At paragraph 19 through 21 of the Harper decision, the court specifically stated, and I quote, "The requirement that any serious sanction against the state be conditioned on a finding of prejudice is well established in our case law. Prejudice must be more than speculative. Therefore, when discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defense preparation for trial." These were defense witnesses, and that bears repeating. These were not state witnesses that the state suddenly disclosed a few weeks before trial. These were their own witnesses that the state put on the witness list on June 2nd. Therefore, Your Honor, under Harper, I would submit to the court that there has been no intentional violation of the court's order. In fact, there has been no violation of the court's order, and therefore the extreme sanction of exclusion is not justified. The state offered and continues to offer. We will agree to extend the pretrial interview deadline. If they wish to interview, yet again, potentially their own witnesses, we have no objection to that. We have no objection to extending the pretrial interview deadline. And that would be the appropriate remedy in this case, Your Honor. With regard to the doctrine of judicial estoppel, I would submit to the court, Your Honor, that this is a doctrine that would not be applicable in criminal cases. And we cited to a case that could be analogous for that proposition, and that's State versus Arevalo. And that's 2002 New
Nice.
Mexico Court of Appeals 62 decision, wherein the New Mexico Court of Appeals refused or rejected the application of non-mutual collateral estoppel. And in that case, the New Mexico Court of Appeals, in citing Standifer versus United States, a U.S. Supreme Court decision from 1980, noted that the question whether the contemporary doctrine of non-mutual collateral estoppel basically is an unknown for New Mexico courts. Now, in New Mexico, with regard to criminal cases, the important interest in enforcement of criminal law and the public interest in the accuracy of justice of criminal results are not present in civil litigation. So what the defense is asking this court to do is to apply a doctrine from civil law to a criminal case. And we have different concerns, Your Honor. We have different concerns in a criminal case as we do in a civil case. And so as the court in State versus Arevalo rejected and refused to apply the doctrine of non-mutual collateral estoppel, this court must reject the defense invitation to apply this judicial estoppel doctrine to this criminal case. The state was not able to find any case where the doctrine of judicial estoppel was applied in a criminal case. And that's because, based on Arevalo, the appellate courts in this state would likely reject the application of that civil doctrine to a criminal case. But assume even if the court were to consider applying judicial estoppel, the state respectfully submits, Your Honor, that the defense has failed to meet the requirements. First, the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. Now, the defense argues that there need not be a judicial decision. The state submits to the court that that is a prerequisite. And even the case that they cite to, matter of state of Kuchan, at paragraph 14, the court specifically says, quote, under New Mexico law, a party successfully assumes or argues a position when the party takes that position before a judicial body, that position is at issue, and the party is ultimately successful. The Kuchan court cites to Wooten versus Vinson, and in that case, the court declined to apply judicial estoppel in a dispute over attorney's fees to the plaintiff's argument that the fees were reasonable, in part because the plaintiff did not ultimately convince the district court that her attorney's fees were unreasonable. This court had not yet ruled on the state's motion. So that prong of the judicial estoppel doctrine does not apply in this case. Counsel argues that, well, it's either a motion or have an order and the first prong is met. Given the language from the Kuchan case, the New Mexico courts, appellate courts, would likely find, and did find in that case, that there has to be some judicial decision as it relates to the position that was taken by the party. But assuming the court finds the first prong is met, I would respectfully submit that the defense has failed to meet the prejudice prong. And the judicial estoppel doctrine requires the defense to establish that they have suffered prejudice. There has been no prejudice in this case. Again, these were defense witnesses who were disclosed by the defense, presumably interviewed by the defense, and that's why they disclosed them, because they obtained information that they believe would be favorable to their position. So there is no prejudice in this case, and we're talking a very short period of time. And again, prosecutors' pretrial decisions carry or enjoy a strong presumption of regularity. Unless there has been a showing of bad faith, those decisions should remain in place, Your Honor. There is no prejudice to the defense as it relates to this particular issue. And as I noted, Your Honor, under Harper, the decision here would be to extend the pretrial interview deadline, allow for the defense to speak to their own witnesses, and any prejudice is cured. And we would respectfully request that the court deny the defendant's motion to exclude these witnesses.
I don't know. We'll get a decision now from
Reply,
the court.
Ms. LeBlanc.
Yes, Your Honor. I'd like to address a couple of the cases that the state has raised. First, with respect to Arevalo, State v. Arevalo. On this case, Your Honor, where they're talking about mutual collateral estoppel. Again, collateral estoppel is a different principle, but what the court was deciding in this case was that.
By the way, this judge, Mary Marlowe Summer, was just great in the Hannah Gutierrez trial. I thought she was awesome. She's very, she's got a very funny demeanor. It's like she's seen it all. She's just waiting for her pension. She's not excited about anything that's going on, but she takes no nonsense, and she's very deliberate and reasoned in her decisions. I like her quite a bit. The judge.
There were two co-defendants, and they each had been assigned separate jury trial settings. At one jury trial setting, one of the co-defendants was found not guilty. Then the co-defendant who was set to go to trial second, then instead filed a motion for judgment of acquittal, asserting that because the other co-defendant was now found not guilty, that the same should apply to him. And so that was what the decision was, and the court, found that there was a lack of mutuality. So this is, a very different analysis than judicial estoppel. There is precedent, however, for the use of civil type doctrines or principles when we look at, for example, specific performance that derives from contract law. And we have cited cases in our motion as well that have to do with the proposition that when the state has made an offer of a plea agreement where the defendant detrimentally relies on that offer, even if it has not been yet accepted by the court, then the state has to engage in specific performance and leave that offer open. So there is precedent, Your Honor, for the inclusion of civil doctrines within the criminal context when it is appropriate. And in this case, it is appropriate in order to maintain the integrity of the judicial process. The other proposition that the state has put forth before the court was that basically criminal prosecutions and their discretion in initiating and conducting those prosecutions will not be disturbed, those decisions by the prosecutors. And for that proposition, they cited Blackledge v. Perry. And in this case that was cited by the state, actually the court did not say that the prosecutorial discretion would stand absent bad faith. They say the opposite. What they said was that even in the absence of bad faith, the state cannot indict on a felony after the defendant had been convicted on a misdemeanor and then appealed the conviction and got a trial de novo. And they said even where there was not bad faith, the prosecution cannot do this because, in fact, they don't want this to have a chilling effect on defendants who would be exercising their right to appeal. And so that is not accurate, that bad faith is the only way in which a prosecutorial discretion can be overturned. And I would ask the court to consider the fact, again, in the state's own words, in their motion that they filed on May 6th, the rules do not contemplate gamesmanship, and this court should not countenance such conduct. I will also point out as a couple of final points that the state talks about, the time the defense had to investigate this case. However, the state has had even longer. The state has had nearly 3 years to investigate this case. And somehow within that short window of, less than 48 hours between when the last witness had been interviewed on May 31st, and then the moment that the defense had had submitted its courtesy copies and filed its notices of withdrawal of witness and also its new amended witness list. Within that period of time, what changed, what additional investigation was had that didn't already take place before.
The
They had
testimony
told the court nothing about
that
any of
Baldwin's
those
finger was
specifics.
on the
What
trigger.
changed was that the defense revealed its position, and then they sought to take advantage. And in addition, the state says that they filed its motion to exclude as a placeholder motion. First, in order to file a motion, there has to be good faith. You have to have an actual basis to file a motion. The state in their motion claimed prejudice. That is different than a placeholder motion. If they're saying it's just a placeholder, then how are they making assertions of prejudice if it's just something there? So it sounds like the state is saying that those are just words that they included because that was the standard that they needed to meet, rather than actually determining that they had suffered prejudice because it was merely a placeholder. So we would ask the court again to grant the defense motion. Thank you, Your Honor.
Thank you for your presentations, counsel. The court makes the following ruling, which will be followed up by a written order.
Good.
The court denies the expedited motion for order excluding witnesses. I did not think that the defense has demonstrated the prejudice that is required under State v. Harper. The defense was on notice that the state may call defendants' witnesses through their May 6th witness list addendum. And given this notice, the court does not find that defendant was prejudiced by the later filed June 2nd, 2024 witness list addendum. With respect to the judicial estoppel argument, that also is denied as part of this order because the doctrine is to prevent parties from playing fast and loose with the court by successfully arguing one position and then later adopting a position inconsistent with the first. And there, I don't think you've met the prongs of, first of all, they didn't successfully argue before the court, and also I don't think that there's the prejudice as contemplated by Cutchin. So you'll get.
All right, first battle of the day. Defense motion to exclude witnesses, their own witnesses, one of whom is going to testify that he watched Alec Baldwin press the trigger when the gun in Baldwin's hand discharged and killed Helena Hutchins. That's a defense witness that the defense suddenly tried to withdraw when this came out, and but now it's a state witness. So, first battle of the day by Judge Mary Marlowe Summer called for the state prosecution of Alec Baldwin. 1-0, state versus defense.